Order in court. In the Moot Court of TRU, this 8th day of February 2022, Her Majesty the Queen and Landon Williams.
Just one more, please. Perhaps if everybody wants to introduce themselves.
Good evening, Chief Justice and Justices. My name is Sterling DERENG, first initial day.
Hey, my name is Salehi, SALEDAIGI, first initial S, and we are representing the appellant, Her Majesty the Queen. Justices, I am McDonald, MACDONALD, first initial A for the respondent.
Justices, I'm McDonald, MACDONALD, first initial S for the respondent.
Could you, appellants, please spell your name, please?
Yes, it's currently D.E. Carter, EMG,
And it's Salehi, SALEDAIGI.
Thank you. You can begin.
Thank you.
Chief Justice, Justices, 6,205 citizens a year, 510 people a month, 17 individuals a day. That is how many people we are losing to the war on drugs. Justices, this appeal concerns the sweeping protection of the accused through the doctrine of entrapment. As stated in MAC, this defense will be available when a person is provided an opportunity to commit an offense by the authorities without the officer having a reasonable suspicion that the person or a location, such as a phone number we add, is engaged in criminal activity. A reasonable suspicion over criminal activity at a certain location is referred to as bona fide inquiry, which involves a genuine purpose of investigating and repressing crime over the location based off of a reasonable suspicion. The Supreme Court of Canada erred by not recognizing the fact that both standards were met by police. The police had a reasonable suspicion over accused.
Counsel, you started at the very outset listing statistics about deaths from drugs. What's the relevance of that? Because you're surely not asking us to declare the Controlled Drugs and Substances Act unconstitutional.
May I clarify the question? Mr. Justice, thank you for the question. So you're asking...
Yes, I'm asking you, what's the relevance of your opening sentence? Because there's a societal debate about the criminalization or decriminalization of drugs, but you have at the very outset stated statistics about deaths, but what relevance does that have to this case? And you're not, I believe, asking this court to declare the certain sections of the Controlled Drugs and Substances Act as unconstitutional. So what's the relevance of the statistic?
Thank you, Mr. Justice. The reason why we provided statistics to show what the current stance on the drug crimes in Canada is, and what we're trying to argue that the police has to act. Police has to use all the tools available to combat the drug trafficking, to combat the drug crimes, and by arguing that the doctrine of entrapment should not be applied in this case, we're trying to say that if accused is using the doctrine of entrapment, there's simply no way for police to combat the drug trafficking. As a result, there will be increase in the death resulted from the drug trafficking and drug-related crimes. Does this answer the question?
Just carry on, please.
Thank you. As I was saying, the police had reasonable suspicion over the accused and the virtual location for prior to the inquiry. Justices, we will be making submissions on 4 issues today. I will begin by addressing the first and second issues, which are whether a phone number can qualify as a location for the purposes of entrapment, and what circumstances can give rise to reasonable suspicion in a dial-up context. Then my co-counsel, Saleh Baghi, will address the third and fourth issues, which examine when a reasonable suspicion can be established in a phone conversation and what constitute provision of an opportunity to traffic in drugs during a phone call. Can a phone number qualify as a location for the purposes of entrapment? We answer this question in the affirmative. A virtual place, such as a phone number, can qualify as a location for the purposes of entrapment, since it provides the link to an individual or association in question. A physical location is a static, identifiable landmark, whereas a virtual location is a dynamic and active. Phone numbers, websites, and chat rooms allow for immediate and interchangeable methods of communication, all done away from the public eye, allowing for more discretion for those involved and the opportunity to access broader communities. Our friends might say, as it was said in Ramelson, that accepting the fact that a virtual location is equivalent to a physical location can raise concerns to the intrusion of the state into individuals' lives. However, this will not be the case. Police investigations into virtual places would not lead to a floodgate of virtue testing, virtue random testing, as police are still bound by their professional requirements of ensuring there is a reasonable suspicion over the person or a location in case of a bona fide inquiry. The court said in Barnes that once a location is defined with sufficient precision, it allows police to present any person associated with the area the opportunity to commit the particular offense in order to investigate pursuant to a bona fide inquiry. This should include virtual locations, as a direct phone number will uncover those associated with the commission of the offense, if the location is being used for illegal activity, as it was the case in Mr. Williams. A phone number is a narrow string of digits that gives direct access to either a person or a location. The physical location where the meetup after the call is malleable and change, minimizing commonly known territory. The police must keep up with these societal changes by including virtual locations for the purposes of entrapment. As stated in MAC, the methods employed by police to detect the commission of crime must begin to match the ingenuity of criminals in order to win the struggle against the crime. For that reason, phone numbers should be treated as a location for the purposes of entrapment. Now we will turn to the circumstances that can give rise to reasonable suspicion in a dial-up context, starting on page 9, paragraph 27 of the appellant factum. The Supreme Court in Ahmed erred by incorrectly concluding that the officer did not form reasonable suspicion based on the information provided. Our friends might say, and as we know from Ahmed, a mere hunch does not transform into something more once placed into hands of police. We agree. However, a lesser burden of proof is required for reasonable suspicion. As Justice Binney said in Kang Brown, a reasonable suspicion means something more than a mere suspicion, and something less than a belief based upon reasonable and probable grounds. Reasonable suspicion is a lower standard. As it was said in Cahill, and this is the key sentence here, it engages the reasonable possibility rather than probability. In the case at issue, police had a reasonable suspicion. This was not a random phone call in the hope to find the drug dealer, as it was the case in Swan, but it rather was a targeted call. One confidential tip, one individual, one location. The police had enough information to act upon the team, similar to the officer's actions in Jones. There, the officer was tasked to attend Unit 39 of the apartment building in Whitehorse as an attempt to purchase crack cocaine. No names, no description, no phone number was given to the officer. It reminds us the importance of the inquiring into every tip and treating them with equal significance. Cahill warns us that merely generalized suspicion is not enough to investigate on, as it would bring a number of presumably innocent people under a subjectively random basis of a search. However, this was not a generalized suspicion. The tip referred to a specific person, specific phone number, and specific location.
Counsel, can I stop you right there?
Yes, of course.
Now, are you saying we should look at reasonable suspicion from the report that was made to the other constable about this individual as a whole of all the police, or should we just look at the one constable who made the phone call? How should we view that as far as applying this test to experiment?
Thank you, Chief Justice. We should look at the totality of the factors. We should look at the broader picture, pardon me. So we should start from the tip. So the confidential informant provided the tip. So Constable Fitkin reviewed the tip and decided to forward it to Constable Hewson, and then eventually Constable Canapa made a call. So we need to look at the totality of the factors. And the fact that police officers, they were part of the drug squad. They know the procedures, they know the rules, and they know how to act upon. So they do trust each other when it comes to when it comes to drug-related offenses and these sort of operations. So we do need to look at the broader picture. Yes.
Thank you.
Well, are you suggesting, though, that there should be some review of the reasonableness of Constable A relying upon the information provided to A by Constable B?
No, thank you, Mr. Justice, but we do not believe there should be a review of the other officer. So and in fact, both officers knew each other. Constable Fitkin and Constable Hewson, they knew each other, they worked in the past together, they trust probably, most likely they trust each other, so they should not review each other's work, so they'd rather have to trust. And moreover, later, during the investigation, they not simply take the tip and act upon, they not simply take the tip and go to arrest the person, but rather conduct investigation, right? They run the phone number through the database, then they conduct the call. And so, yes, they trusted the officer, but they did thorough investigation as well. Thank you. The confidential tip in the current case is comparable to those which are provided through the Crime Stoppers program.
Okay, so counsel, you can assume that we have read the factum, all right? So ultimately, you're asking the court to do what's just, what's the right thing here, based on the various burdens of proof in your when it comes to entrapment. So what we're struggling with is you're asking us to draw a very fine line here. I mean, if one distinguishes Ahmed and Williams, the two facts, there's a very fine line there. And we have to do what's in the interest of justice for this individual or the individuals that you're representing. You're asking us to do that. So what in your submission factually or in the evidence in this case would make it not entrapment versus why it's entrapment? Because there's a very fine distinction, splitting hairs, which the average reasonable person on the street might have difficulty comprehending. And we have to uphold public confidence in the administration of justice as well, including as it applies to your client. So I have difficulty seeing what more could the police officer have done when he phoned Mr. Williams to make it reasonable suspicion. We're talking drug deals here. It's not like you have an extended conversation. That's the reality of criminal courts, is there's coded language, there are quick conversations, they're clever. So what more could the officer have done to make it reasonable suspicion, where you're saying that was lacking?
Mm-hmm. Thank you, Mr. Justice. Constable Canepa, while he was doing the call, conducted an investigation. So it was, so we argue both sides. So we argue that there was a reasonable suspicion prior to the call. And if...
So can I ask you, is it apparent from the evidence, or maybe it's not, the informant call that comes in, is it anonymous or is it a known source?
The fact, well, the tip was, it was a confidential informant. It was a confidential informant Fide can receive the tip from.
Well, confidential informant can be a known confidential source protected by police informer privilege, or it can be a Crime Stoppers tip where somebody just phones in and leaves a recording. Mm-hmm. So I'm trying to distinguish, see what relevance that might have. So when one gets a confidential tip, informer tip, I need to be able to ascertain what steps the police took, or we need to be able to ascertain when one looks at it completely to determine whether there was reasonable suspicion or not.
Mm-hmm. Well, not to step on my co-counsel toes, who will expand on what information is important before and during the call. However, I would like to add the tip. Yes, the tip was received. What police did, the Constable Fide created the person of interest package, right? So they simply, as I mentioned earlier, they did not act it right away once they received the tip. They conducted investigation. And that's what, answering question, Mr. Justice, what they could do more to review the reasonable suspicion, whether reasonable suspicion is established. So they either have formed it before, if not, they form it during the call itself.
All right, well, let me try to help you out here. Does the record from the trial indicate that the informant was a known informant, or was it an anonymous phoned-in tip? What's because facts are relevant to judicial outcomes. The evidence, what did the evidence say? Or do we know? Maybe we don't know. Can you assist the court?
Yes, thank you. The evidence shows that it was a confidential informant. However, it does not expand on that. So what we're trying to say here, and most likely our friends might expand on that as well. However, since there was no information, there was no more information about the informant, where this is we believe that the Fide, since they did not provide more information, they trusted that informant. They probably worked with that informant in the past. And we're also actually trying to argue that in 2000...
Probably is not something that the court is going to really entertain seriously, because we can't engage in speculation, right? We have to be guided by evidence or an absence of evidence.
I agree, yes. Speculation will not work here, I do agree. From what we have, from evidence standpoint, from what we have, so we're trying to say there was a trust to that informant. And if, as our friends may argue, that there was not enough, we submit that there was, even if there was not enough. So once we argue that every tip is important, right? So we do provide an example of kidnapping case. So every tip should be acted upon. And while they're acting, so they receive the tip, and so they don't act right away and arrest that person, but they do conduct investigation. So they do review whether there are grounds for reasonable suspicion there. So what I'm trying to say, tip is important, so we have to look at every tip. But however, police have to conduct their investigation as well, and that's what they did in this case. They made a call and they did not jump straight to providing an opportunity to offense, but they'd rather use the slang and made a call, and we're trying to investigate whether that person is actually Jay and whether that person is involved in drug trafficking, as it was here.
So the evidence suggests that there were 2 transactions in February, right? 10 days apart.
Correct.
And so are you asking the court to say that the whole house of cards ought to fall here because of entrapment? But what relevance does the second incident happen? Because by then, presumably, when we look at it, there is further evidence. There's identification of Mr. Williams. There's been a drug transaction. So how does the second charge or second incident also stand, or do we distinguish it from the first? By the second, is there reasonable suspicion established? Is there a nexus to the very first phone call or not?
The very first charge is of the most importance here. The second charge is important as well. However, reasonable suspicion was established in the first one. And the second, it helps our argument this way. Our friends in Ahmad argued that there is a risk when police conducts investigations without reasonable suspicion that the person who is picking up on the other phone, on the other side, it might not be a drug dealer. It might not be a person dealing drugs. However, the police provides that opportunity. They induce that crime, right? The second charge, the second transaction, solidifies the fact that it was the person who is dealing drugs. Thank you. Mr. Justice, would you like me to expand on Crime Stoppers' argument?
No, you should be mindful of your time allocation and proceed to what you think is important. You guide the court. We will ask the questions that you ask me clarify.
Okay, thank you.
But I've interrupted you enough times. I would like you to get to the nub of what you think is important.
Okay, thank you. I would like to expand on the Crime Stoppers program, so it looks like I do have enough time. As it was said in Bank, there is evidence that there is a high degree of reliability of such tips, of Crime Stoppers tips. In almost every case, the court says, Crime Stoppers tips have resulted in police verifying the accuracy of the information in relation to a dial-up scheme. That is when we provide the example with kidnapping. So when a child is kidnapped, each tip, each piece of information is reviewed, is important, and is looked seriously, and taken seriously in hopes of saving that missing child. And the tips surrounding the commission or use of drugs should be taken as serious. We also expanded briefly on that. However, I would like to underline that even if police did not have the name of the person selling the drugs, it would have been enough to have the phone number believed to be involved in a criminal activity. This was the case in Bank, where it was said that since there was a reasonable suspicion relating to a phone number, and that's part of bona fide inquiry mentioned earlier, it was permissible for the police to provide an opportunity to sell drugs to whomever used that number. So what we're trying to say here, that even if there was no even if there was no direct contact that Jay or Mr. Williams was the person involved in drugs, in selling drugs, there was reasonable suspicion over the phone number, because it is a virtual location. It should be treated as the physical location. There was a reasonable suspicion over that location, and the police had to act on And as it was said in Barnes, once it is established that there is a reasonable suspicion over a location, which should include the phone numbers as a virtual, then any person could be offered an opportunity to commit an offense.
Counsel, do we have any evidence that connects the alleged drug dealer on phone call 1 with phone call 2 being one and the same person?
Yes, they refer to an MJ. So,
No, well, the name is Jay, but how do we know that it was the same person who is pretending or is asserting that they're Jay on call number 1 and call number 2?
this is thank you, Mr. Justice. This is a good point. If, as I mentioned, if there is no reasonable suspicion over that person, we still have that reasonable suspicion over the phone number as a location. So that's why it should have been enough. And as we argued in the Supreme Court, sometimes drug traffickers use different names. And as my co-counsel will expand, sometimes they use different nicknames in order to recognize who is the caller and what drug to offer. And as we argued in the Supreme Court, the fact they could be that the one phone number could be associated with the business involved in drug trafficking. So it could be one person answering the phone. However, there could be a number of people running that business transaction, running that business operation. Could be 10 people in a.
And that phone can just get passed around.
Correct. Yes. So that's why there is importance of having that reasonable suspicion over the phone number, as it was in Barnes, where it was established that there was a reasonable suspicion over the mall area, the 6-block radius where criminal activity occurred. Thank you. Now I would like to address the reliability of a tip. And Garofoli set forth the test for assessing the reliability of a tip, which should be looked at in consideration of the totality of the circumstances. The court set out 3 factors. First, the degree of the detail of the tip. This was not a tip about an individual selling drugs in a mall, but it rather was a detailed tip about a specific location, a phone number, a person named Jay, who was selling drugs in Queens and Church area. Police had sufficient information to act on. Once again, going back to that difference between possibility and probability. So we argued that there was a possibility of a crime here. That's why police had to act. Next, the informer's source of knowledge concerning Mr. Williams' drug operation is detailed and specific, showing that it comes from either first or second-hand knowledge. Lastly, the reliability of the informer must be examined. Police Constable Fide accepted the informer's tip and passed it on to Detective Hewson, showing the basic level of reliability of that confidential source, as we briefly expanded on that earlier as well. By wanting to remain confidential, it is reasonable to believe that the informant has some validity to the information that they're sharing, which is why they would like to remain anonymous. And as we briefly discussed as well, although it was somewhat a speculation, however, we're unable to rule out the possibility that the confidential source was linked to Mr. Williams' arrest in 2009, and I will explain why. It was the same charge, drug trafficking, the same area, it was Queens, and it was only 12 minutes away. And also the fact I want to bring if we go back to the facts and the dialogue, the exchange during the phone call, Constable Canepa refers to him and provides an explanation how he got the phone number of Jay. He referred to that someone from Queens and Jarvis area gave him the phone number. So that's, once again, it's all the same area. And that very undercover officer that was involved earlier could have been the source Fitkin received the tip from. That's what we're trying to establish, that connection, which was not quite given here. And the source which Fitkin could not share for the safety of the officer. This is our argument here. And these are my submissions. And now my co-counsel, Ms. Talebegui, will address the issues that follow. Thank you.
Justices, in addressing the third issue, we began on page 16, paragraph 53 of the appellant's written factum. The Supreme Court of Canada in Ahmed reminds us that police investigating a dial-a-dope operation by calling a phone number they suspect is being used to traffic illegal drugs must form reasonable suspicion before offering an opportunity to traffic. The courts must review not only the conversation that occurred between police and the accused during the call when establishing whether reasonable suspicion manifested and an opportunity to defend was offered, but also the steps involved prior to making the call. The court in Ahmed claimed that a phone number and name is insufficient to amount to reasonable suspicion and that it risks the possibility of random virtue testing. They further state that just a hunch or a mere suspicion of one police officer cannot become something more simply because it was shared with other officers or when given to police by an informant. The chain of inferences offered prior to the call by the confidential tip, the phone number, the location where the drugs are being sold, and the fact that the accused has a criminal past for a related crime provides the officer with more than a mere suspicion. The accumulation of all material establishes reasonable suspicion. Investigating a specific type of crime within a tightly circumscribed location, whether physical or virtual, constitutes a bona fide inquiry. The officer's investigation was not done in bad faith, as they did not target the individual, nor were there any issues of racial profiling, stereotyping, or reliance on vulnerabilities that occurred. In fact, the officer had informed his team that he wanted to know as little as possible in hopes of preventing any biases. An investigating officer only knew the accused's name, the phone number, and the nature of the drug. In Hill, it was found that the information from a fellow officer that a source was pretty reliable rose above being a bare, unsubstantiated tip that someone was dealing drugs from a phone number. The court found that information compelling and credible. Police obligation does not require further investigation to seek out exculpatory factors or rule out possible innocent explanations. Their duty involves addressing information provided of wrongdoings or addressing serious harms that may occur. Reasonable suspicion should further be assessed in relation to police knowledge and experience, providing them with objective reasonableness of suspicion over certain crimes. Factors such as working under a false name can give rise to reasonable suspicion for experienced police officers such as Fitkin. We draw a parallel to tips offered by drivers on the road who believe another vehicle is under the influence. These individuals are asked and encouraged by police to call in or report whatever information they may have, whether they are right or wrong, through Campaign 911, sponsored by Mad Canada. This tip is towards a targeted individual or car.
Counsel, do you need more time?
Yes, please.
That's all right.
Thank you. The tip is towards a targeted individual or car that is acting in a way that someone believes is unlawful and dangerous. The tip is enough for officers to begin an investigation. It is not a random check, and the information provided rises to a mere suspicion that the officers still inquire about. There is no difference with inquiring into a virtual location after a tip has been made regarding a phone number, especially when more information, such as an address, as it was the case for Mr. Williams, is included. Similar to information on drunk drivers, the officers are able to do more research and find information about the individual in control of the phone. But the tip provides more than a mere hunch that they are conducting a crime. During the phone call conversation itself, the conversation was enough to manifest reasonable suspicion to the officers. By not denying that he is Jay, the accused confirmed that the confidential tip was correct in the sense that the virtual location was being used for a drug operation, which allowed officers to continue with their bona fide inquiry. The accused voluntarily confirmed this identity without knowing who was on the other side. This allowed for reasonable suspicion before the police offered any opportunities to offend. Since the investigation was conducted via the phone, the police provided an accused the opportunity to hang up the call once he was disinterested in the conversation, allowing the accused to leave the virtual location should he felt as if he was being persuaded to do something he did not want to do. The police conduct can be contrasted with investigations that occur in person, such as in barns. There, the accused turned the officer down on his request for drugs, but after some persistence, the officer received a positive answer from the accused and sold to him, leading to the arrest shortly after. In examining the conversation during the call further, the Supreme Court of Canada erred in Ahmed when they stated that the opportunity to offend was offered by police once they asked for 80. The number 80 can be associated with numerous things such as money. It did not have sufficient detail to constitute an opportunity to traffic drugs. If we look at Ahmed, the officer said he needed 2 soft, and in Inaugural, the officer asked the accused if he could help hook him up. Both cases were using more commonly known drug slang. In both, the accused had asked the officer what they needed after being told the specific drug they were seeking. We differentiate that from Mr. Williams' case, where the police never specified what they were looking for until after the purchase was confirmed, and the accused asked whether the officer wanted soft or hard. We can further contrast with Bank, where the officer asked, "Can you do a ball?" The statement is posed as a question to the accused, which upon confirmation would allow for officers to continue with their investigation by allowing for an opportunity to commit a crime. Whereas for Williams, the officers did not ask for drugs, but rather stated that he needed 80. This is because the leading question to whether the accused is associated with drugs was when they asked whether he was Jay. The name and phone number collectively were associated with the tip for drugs, which upon confirmation allowed for the opportunity to ask for 80. Prior to the investigatory phone call, police had reasonable suspicion that a particular phone number was engaged in criminal activity, which was further...
Counsel,
Yes.
one of the things that might concern this panel is perhaps the failure of the courts underneath to look at the aspect of when police officers at Fitkin, there was preparing of a persons of interest package. And there's a photograph, a date of birth, street address, and so forth, and a description, black male, 6 foot 1 inches, 150 pounds. Frequently, appellate courts hear about police investigations which lead to miscarriages of justice, where the police end up with tunnel vision. This aspect of the case concerns me. So how should this court deal with it, if at all, as it fits in with the whole of the circumstances that underlie this case? Because that's pretty early on in this investigation where the police basically, there's an inference here or a concern that the police may have discounted other avenues of investigation and just basically made up their mind and proceeded down the tunnel that leads to the conviction or lack of it, we'll see, of Mr. Williams. So how should the court deal with this, if at all? Is it relevant or not?
Thank you, Justice. We do believe that it is relevant, and we would like to stress the fact, like my co-counsel did, that there was an investigation that occurred. They took about 10 days after they received the tip to make the POI and inquire about the information on the accused. They further did not arrest him after the first transaction, but they wanted to do not 1, but 2 more. Upon the 3rd attempt, the accused did not pick up the phone, which is when they arrested him. We further will be making the argument later on that the accused himself is not of interest. More specifically, it's the virtual location that we are inquiring into. The accused just happened to be who he is, but should have been another person. They would have been involved with this virtual location, which is what is trafficking drugs. It's the same as if they were on a corner of a street and it just happened to be someone's giving drugs there.
Thank you.
So, in addressing the final issue on page 20,
Counsel, I think your time is up. I'm sorry.
Oh, okay. Thank you.
Justices, my name is Allison McDonald, and I am appearing as counsel for the respondent, Mr. Landon Williams. I will be speaking for 15 minutes and will address the first two submissions. My co-counsel, Sam MacDonald, will be speaking for 15 minutes and will address issues 3 and 4. The first submission I will be making is that a phone number qualifies as a location for the purposes of entrapment. The second submission is that a tip that has been sufficiently corroborated can give rise to reasonable suspicion in the dial-a-dope context. But in these circumstances, no corroboration of the tip was completed, and as such, the police lacked reasonable suspicion in their investigation. Justices, this is a case about balance. It's about maintaining the balance between police's ability to effectively fight drug trafficking and the right to personal privacy. It's about keeping state intervention in check against unreasonable search and seizure, and again, keeping police required to meet just a minimum evidentiary standard. The respondent in these proceedings has been convicted of drug trafficking, a serious crime. And police do need to be able to effectively stop drug trafficking. However, this cannot come at the expense of personal autonomy and human dignity. The respondent asks this court to ensure that the safeguard of entrapment is indeed providing safety from abusive processes. We ask this court to dismiss this appeal and reinstate the stay of proceedings in favor of the respondent. I will now address issue 1, which begins at page 7, paragraph 6 of the respondent factum. A phone number can qualify as a location for the purposes of entrapment. On this point, both the respondents and appellants agree in these proceedings. The Supreme Court of Canada in Mac determined that a phone number may be a location where it's sufficiently narrow and defined. No case following that decision, which was rendered in 1988, has dissented on this point. Now, recent decisions, including Ramelson, as brought up by the appellants, have upheld this conclusion. Now, it should be noted that not all digital communications will fulfill this sufficiently narrow and defined threshold. A phone number will not be sufficiently narrow.
Counsel, in reviewing the record or the judgments from the lower courts, for example, the Supreme Court of Canada, the Supreme Court of Canada in the dissenting or dissenting in part, there's a statement by the justices there, and I'll just read a couple of sentences. Whether the precision of the location meets this threshold should be determined by reference to the overarching question that entrapment poses. That is, whether in all of the circumstances society would view the inquiry as abusive. Now, I understand, because that's what lawyers do and judges do. We get into the technicalities and we get into the examination of reasonable suspicion. But ultimately, the question is, what is the mischief here that's at stake? And what is it about the police conduct that would make it abusive, such that it should remain, and this court should uphold that there was entrapment here? What was it in the police conduct that makes it abusive? I'm not so interested in parsing over and over in detail what is reasonable suspicion, because it's very fact-driven, it's very specific to each and every case. But ultimately, we have to look at what's the right thing on the evidence in this case. What was it that you say that the mischief that should be protected here and guarded that makes the police conduct such that it's abusive, unsavory, and would bring, if we were to reverse this and convict him, that would bring the administration of justice into disrepute?
Justice, this seems to bring to mind the clearest of cases definition that's discussed further in that decision. And essentially, that's just when police act without a factual basis, without evidence to support their actions. And the court has gone on to say in that decision, as well as in Mac earlier, that the facts the police are acting on have to be judicially reviewable. They have to be objectively discernible. And unfortunately here, as you pointed out, it is very factually specific. Here we don't have that evidence. We don't have those facts. We do not know why Constable Fitkin connected this tip to Mr. Williams.
Do we need to know? I mean, maybe the police got lucky What's the abuse here?
Justice, we do need to know, especially in circumstances of entrapment, because police could be acting on a mere hunch, on a guess, on anything. And the court has warned against this random virtue testing, essentially casting a wide net and trying to catch whatever falls within that net. The court warned in Swan, the BC Court of Appeal, that police cannot do that. That is random virtue testing. That goes beyond the scope of their abilities as police officers. And this was addressed a bit by the appellants in that they suggested that the police should be believed on a good faith basis, that they're bound to professional ethics, which is true. But the respondents submit that the police are also bound to the law. They're bound to their processes. And the process for this requires them to have an objectively discernible basis for reasonable suspicion, which is unfortunately lacking in these circumstances.
Well, in this case, Mr. Williams, the police officer makes the reference to the 80, which is street vernacular for drugs. I mean, what's wrong with getting to the point of what one wants? How does that make the police conduct mischievous? There's a prelude, a couple of sentences or whatever in the record prior to the police officer raising that, but what makes the conversation unreasonable to conclude that it's pretty clear that it was very quickly moving towards a drug transaction? This court frequently hears about how drug transactions occurred. They're brief, they're to the point, they're protected. Drug dealers are clever. So again, I'm seeking your assistance in determining. I don't want to get bogged down on reasonable suspicion. We know that there's law on that. We know society evolves. I mean, Mac and so forth were rendered quite some time ago. Cell phones have come a long way in how almost everybody has one. And drug dealers use them all the time. We hear it all the time. So again, on the totality of the evidence, what is it that makes this entrapment? Such that we should, even though there's a guilty plea, that we should say that this is contrary to the spirit of the charter, that it is abusive, and to convict him would bring the administration of justice into disrepute. That's the big question.
Justice, in providing that I need 80 statement, the police detective Canepa was acting without reasonable suspicion, which you addressed. And in that, he didn't have a factual basis for acting. So again, it could have just been random. He could have had a personal vendetta against Mr. Williams. It could have been anything. And what's required by police is that they provide evidence as to why they acted. We do not know why Detective Canepa asked, I need 80. We do not know what information was reliable, was assessed, because that evidence just hasn't been provided here. So in these circumstances where the real issue happens, where the entrapment happens, is the fact that Detective Canepa provided that offer, I need 80, without confirming or corroborating any part of the tip that was provided. The reliability was not assessed. Detective Hewson said she knew nothing about any reliability checks and that she knew nothing about the circumstances. They did have a meeting discussing it, but again, we do not know what this decision was based off of. And procedurally, it's required that police provide the information that they made these decisions based off of. And this case is quite similar to a case, Marino Montero, where Justice McMahon essentially looked at the exact same circumstances, the exact same phrasing actually, because it was the same Detective Canepa in those circumstances. He used the same name, Vinny, and in those circumstances there, Canepa said, yo. The accused or the target said, who's this? Canepa said, Vinny, is this Q? The target said, yeah, who's this? Canepa said, Vinny. Mike from Yorkville gave me your number. I need 40. The court in that case determined that I need 40 was an offer provided to the target without reasonable suspicion, because in that conversation, in that short conversation prior to the offer, reasonable suspicion was not grounded. Despite confirming Q as the suspected nickname, despite the target answering and saying hello and staying on the phone. Justice McMahon found in that case that the tip, even though it was specific to a person, still was not corroborated. And as such, the police, Detective Canepa, again, in that circumstance, had acted outside the process, had acted outside the legally allowable procedure for investigations. Now,
Counsel, can I pick up on that just quickly? What do we expect from law enforcement? To call somebody up on a suspicion of a dial-a-dope situation and ask if they're going to sell them drugs on the phone? Like, the vernacular needs to be used in order to try to get somebody to actually offer drugs sometime. Now, does I need 80 mean I need drugs? What would that mean to me if somebody called and said I need 80? It would mean nothing to me, but somebody who sells drugs, it does mean something to them. Does that matter? Does it matter where we draw the distinction as to who says I need 80 or can I buy drugs? Because I don't imagine that Jay would answer the phone and say, yes, you can buy drugs.
Chief Justice, yes, this matters quite a bit. My co-counsel will speak to this in issues 3 and 4, but to answer it quickly, the phrase I need 80 has been found across many jurisdictions to refer only to cocaine. So when there is a number provided, 40 in that previous Marino-Montero case, 80 as in here, that means cocaine in the coded drug language. Now, to an average person who's not attuned to this linguistic specificity, this may just seem like an odd number, but in the drug language, a number alone means cocaine. And that's why Mr. Williams knew, or one can assume that's why he knew, to ask the next question, which was hard or soft. And this is specific to cocaine, which shows that he understood the discussion was surrounding that drug. Now, my co-counsel will speak a little more in definition about that topic.
Well, yes, the constable or police officer Kanepka does says, you need to help me out, I need 80. But I suppose somebody could phone somebody and say, I need 80 loaves of bread, phoning a wrong number. As the conversation goes on, though, this person says, you want soft or hard? So we have to look at the totality of the circumstances. I don't think a baker would say, you want soft or hard? So this is within the nexus of the drug trade. Where should we be drawing the line here when we look at what's the just outcome here?
Justice, in offering I need 80, where he did in that conversation, he did so before any information or any reasonable suspicion could arise. In these circumstances, timing matters. The police cannot Monday morning quarterback the reasonable suspicion in entrapment. They have to have it arise prior to making that offer to commit a crime. And so, yes, they did discuss drugs further down. Yes, there were drug deals that happened as a result. But this came from an offer that was provided before any reasonable suspicion was grounded. And the police had many opportunities to ground this reasonable suspicion. They could have done so by corroborating through investigation, and they could have done so by corroborating during the conversation itself. But none of these instances occurred. We don't know what happened with any investigation. This evidence was not brought to the court, and we do know what happened in the conversation because we have that wording in front of us. We know that this is the exact same wording as in Marino-Montero, and we know that this wording does not give rise to reasonable suspicion.
Well, I asked the appellants what more could the police officer have done in a reverse kind of to try to help draw where the line, a reasonable line, should be drawn. And so give us an example of how should the police officer have proceeded with the conversation once he says, you know, when he's asked, who is this? It's Vinny. Vinny who? Vinny, Jesse from Queens, and Jarvis gave me your name, said you could help me out.
Justice, there were two circumstances where the police had an opportunity to corroborate this tip further. And the first happened even before the phone call occurred. And this could have been through cross-referencing phone numbers, considering the reliability of the informant, the relationship of the informant, the length of time the informant had worked with police, and any possible motivations for providing a false tip. Now, This unfortunately was not done, we know through the facts of this case. But corroboration during the conversation could have also arisen. And this could have occurred, which normally occurs during conversation. In Ahmad, we saw, what do you need? And this is a coded conversation that the Supreme Court found did ground reasonable suspicion. So what Detective Canepa should have done in these circumstances is simply converse about drugs with Mr. Williams. Engage in a conversation, whether that be coded or whether that be simple. Just get enough information.
What would he say? Have you heard of drugs? Do you sell drugs? What kind of drugs do you sell? How far away are you? I mean, it seems to me to be superfluous. The thing is ultimately, and I'm repeating myself, is I think it's important that, yes, we can look at the textbook perfect case, but ultimately, we have to look at what's the just outcome. And I'm struggling with what is what's the mischief here, and why? What more could the police have done? Because I don't see any misconduct on the police. It's maybe not the textbook perfect case, but in some ways maybe he got lucky. Got right to the point. Went, drug transaction happened. It's for sale. Money is exchanged.
Justice, this misconduct or mischief arose out of an absence of reasonable suspicion. So it wasn't what the police did prior, it's what they didn't do. We know that they didn't corroborate that tip in investigation. And in the conversation, we know that the offer, I need 80, was provided before the rest of the conversation about drugs that was in greater detail. So that's where the mischief occurred.
Why should we be bound by the previous precedent? The law grows. The reality is that, we live in a different era here. Section 8 of the Charter, for example, there's expectations of privacy against search and seizure. We understand that, but this wasn't getting into somebody's car or somebody's house. It wasn't even a search warrant case. It's a telephone case. It's a simple set of facts, or apparently a simple set of facts. So why should we be bound by some of the precedent you're eliciting? Is it relevant in today's age? With the nature of drug trade, with the mischief and harm that the drug trade causes, and the proliferation of drug transactions by cell phones, which everybody has these days, including the drug dealers.
Justice, the respondents submit that it is vitally important that we look at this in great detail, especially with regards to timing and when that offer was presented. The police cannot arrest someone. They cannot investigate in a manner where they have no grounds, where they don't have any reasonable suspicion, where they haven't corroborated anything. Essentially, the mischief or fear here is that it would allow police to randomly virtue test, but it would also allow them to act out of hunches, out of their own personal views. It would allow them to act out of essentially anything which is not judicially reviewable and not grounded in evidence.
The reality is human nature is full of all kinds of examples that meet with success, from scientific discovery to police solving serious crimes on hunches. The issue really comes down to is, should it be admissible, or should there be a remedy for wrongdoing? And I'm struggling with that. What is the wrong here? There doesn't have to be an absolute checklist that perfectly is done by police officers. Checklists can even change with changing circumstances, technology, and societal needs. The issue is what is it about the police here that says that the extraordinary remedy of entrapment should be concluded and found in this case?
Justice, that should be the case in these circumstances because the police acted far outside the scope of their abilities, and they are bound to laws. They are bound to this procedure, which they must adhere to. Otherwise, they are entrapping people. They are reducing human dignity and personal autonomy in the public. And I am wary of time, Justice.
All right. So yes, your time is coming up, so I'll be very, very quick. You've referred to the public, but if the public were looking at this, and a reasonable, fair-minded member of the public, and if we said there was entrapment and there should be a stay of proceedings, would they understand and agree with the decision of the Supreme Court?
Justice, this was addressed by the Supreme Court, and it was also addressed in MAC at page 958, and they discussed that this standard for police to meet, or entrapment rather, is much lower than a community shock or community shock of conscience. That's not what's required here. All that's required is that the police ground the reasonable suspicion in some sort of evidence. This was not done in these circumstances. I will now turn the podium over to my co-counsel, Sam MacDonald, for issues 3 and 4.
Justices, I will present for the next 15 minutes on issues 3 and 4. Regarding issue 3, which concerns how courts should review the conversations between police and the accused, the respondent submits that courts should review the precise words spoken between the police and accused with reference to context and timing. Regarding issue 4 on what constitutes an opportunity to offend in the dial-a-dope context, the respondent submits that a request for a specific amount of drugs constitutes an opportunity to offend. If this court adopts these submissions, it follows then that Detective Canepa provided Mr. Williams with an opportunity to offend without having reasonable suspicion, and as a result, Mr. Williams was entrapped. I will now turn to issue 3, which begins at page 14, paragraph 25 of the respondent factum. It is the respondent's position that if reasonable suspicion does not arise before police call a tipped phone number, then courts should review the precise wording of the call between the police and accused. The Supreme Court of Canada in Ahmed and Williams affirms this proposition, and it was implicitly affirmed by the Ontario Court of Appeal in Ralph. The aim of this review is to determine whether reasonable suspicion arose during the call, and if it arose before an opportunity to offend was presented to the accused. To achieve this aim, courts should consider the timing and context of the call. Contextual factors like drug trade language or information contained in an anonymous tip may indicate if reasonable suspicion is established, and timing indicates whether this occurs before or after the provision of an opportunity to offend. Justice, admittedly, this is a fine line, but it is a line nonetheless. The BC Court of Appeal in Olazo, and is affirmed on appeal by the Supreme Court of Canada, supports this type of review and is illustrative of this review in action. In Olazo, police received a tipped phone number with the claim that it was being used for a 24-hour dial-a-dope operation. Police called the tipped phone number at 2 a.m. and asked the accused, "Can you meet me?" The accused responded positively and later met with undercover police to sell drugs. The court reviewed the precise words spoken between the police and accused and found that reasonable suspicion arose during the call because of 2 reasons. First, the fact that the accused answered at 2 a.m. corroborated the source's claim that it was a 24-hour operation. And second, the accused's familiarity with the phrase, "Can you meet me?" a phrase common in drug trade language, corroborated the source's claim that it was in fact a dial-a-dope phone number. And as for timing, the court found that this all occurred before the provision of an opportunity to offend, which occurred later in the conversation. Here, and as demonstrated by co-counsel MacDonald, police did not possess reasonable suspicion before calling the tipped phone number. They only possessed a bare tip. As such, this court should review the precise words spoken between Mr. Williams and Detective Canepa with an eye to timing and context. And importantly, this type of review excludes any consideration of events taking place after the provision of an opportunity to offend. For example, any drug trade taking place after the provision of an opportunity to offend may not be considered in this review. Justice, I believe you raised the fact that 2 drug transactions occurred after the call took place. This type of review excludes that from consideration. And this rejection is warranted because reasonable suspicion may not arise retroactively. In other words, police cannot justify intervention based on information they gained after they act. This proposition is supported by the majority of the Supreme Court of Canada in Ahmed and Williams. And the Ontario Court of Appeal in Ralph implicitly rejected this approach, which is referred to as the totality of the exchange, taking events that occur after a provision of an opportunity to offend in account. And they opted to review the precise words spoken between the police and accused in alignment with Alazo and Ahmed and Williams. In that case, police received a tipped phone number, made the call, and successfully arranged to meet the accused on 6 separate occasions to purchase drugs. However, the court did not factor these 6 drug trades into its consideration of if and when reasonable suspicion arose. Here, Mr. Williams did meet with undercover police to sell drugs on 2 occasions. However, according to Ralph, these events must be excluded from this court's consideration of reasonable suspicion, as they occurred only after the provision of an opportunity to offend. In the same vein, the precise wording of the call indicates that Mr. Williams was in fact familiar with drug trade language. This was a contextual factor that could have established reasonable suspicion. But again, the timing of the call indicates that this occurred only after the provision of an opportunity to offend, so it too must be excluded. To reiterate co-counsel McDonald's submission, reasonable suspicion did not arise during the call before the provision of an opportunity to offend. An examination of the precise wording of the call with reference to context and timing supports this conclusion. Turning now to issue 4, which begins at page 15, paragraph 28 of the respondent's factum. The respondent submits that a request to purchase a specific...
Counsel, in the Ahmed decision of the Supreme Court of Canada, paragraph 149, in the dissenting portion, or partial dissent, that paragraph reads, "It is worth noting here that no comparable jurisdictions that recognize the doctrine of entrapment require individualized reasonable suspicion in order to extend a mere opportunity to commit an offense," quoting Professor Kent Roach. And later in paragraph 150, in referring to the reference to the House of Lords, the Supreme Court of Canada goes to say, it goes without saying that police must act in good faith and not, for example, as part of a malicious vendetta against an individual or group of individuals. Having reasonable grounds for suspicion is one way good faith may be established, but having grounds for suspicion of a particular individual is not always essential. Sometimes suspicion may be centered on a particular place, such as a particular public house. Sometimes random testing may be the only practical way of policing a particular trading activity. So when I look at this, I keep repeating myself, but why should I or the court be focused purely on previous jurisprudence around reasonable suspicion when this type of approach that I've just quoted seems to me to be more comprehensive and adaptable, more flexible and responsive perhaps to the individual facts of a case?
Justice, the respondent submits that under this current approach, dial-a-dope operations may still be investigated by police without causing entrapment. This occurred in Ahmed, the case alongside Mr. Williams. And admittedly, it is a subtle difference, Ahmed and Mr. Williams' cases, but in Ahmed, the police, they wait for Mr. Ahmed to respond to their prompt of, "Are you around?" This is a merely investigatory statement that police may ask the accused, ask the target, and it can occur in a variety of ways. "Can you hook me up?" is another example. And there, police waited for a response. They waited to establish reasonable suspicion. And the difference with Mr. Williams, of course, is quite subtle because Detective Canepa simply did not wait. He said, "Are you around? I need 80. So, Justice, under this current system, it is still possible for police to investigate dial-a-dope operations successfully. In fact, Detective Canepa himself knows personally that he cannot go straight to an opportunity to offend. He learned that in Marino Montero. It is appropriate for this court to follow that same line of reasoning, Justice. Turning now to issue 4.
Counsel, I'm going to stop you for a sec. What if the detective said, "You got 80"? Not "I need 80", but "you got 80". Would the answer to that question, let's say in the affirmative in some way, be enough to create that reasonable suspicion?
Chief Justice, perhaps it would not, because under the definition of drug trafficking, it is an offense to actually traffic drugs, but it is also an offense to offer trafficking drugs. Merely being in possession of drugs, which that question asks the answer to, may not meet the definition of drug trafficking, but perhaps possession of drugs. And for that reason, reasonable suspicion for drug trafficking may not arise after that phrase.
I get your literal point, but let's step back for a moment. Let's say it led to the conversation that talked about hard or soft or something like that afterwards. Like, is it okay for the detective to say, "You got 80"? Saying "I need 80" suggests there's a transfer or I want an exchange with you. Obviously, there's something more implied with "I need 80". It's implying something to the other person on the phone. But "you got 80" is just confirming a reasonable suspicion by the police officer that this person knows what that means in the drug vernacular, and then goes forward and then later says, "Okay, I need 80", right after the person confirms that they got 80. Do you think that's entrapment?
Chief Justice, perhaps not in that circumstance. The context does matter. For example, the fact that the tip contained the information that Jay was a cocaine dealer contextualized the conversation, because "I need 80", of course, refers to $80 worth of cocaine. In that instance, context tells us exactly that. So because of that, Chief Justice, it could constitute an opportunity to offend. It could be entrapment, but context would have to be taken into account before making a definitive answer, Chief Justice. Turning now to issue 4, which of course refers to what constitutes an opportunity to offend in the dial-a-dope context. The actual phrase "I need 80" is similar to other statements that were found to constitute an opportunity to offend in the dial-a-dope context. For example, in Marino Montero, as co-counsel McDonald introduced, the Ontario Superior Court concluded that the phrase "I need 40", which was found to refer to $40 worth of cocaine, constitutes an opportunity to offend. Similarly, in Izzard, the Ontario Superior Court found that the phrase "I need 6 greens", which refers to a quantity of Oxycontin, constitutes an opportunity to offend. And in Ralph, the Ontario Court of Appeal came to the same conclusion with the phrase "I need half a B". Common throughout all of these foregoing phrases is a specific quantity of drug that's listed under Schedules 1 to 5 of the Controlled Drug and Substances Act. It follows then that the phrase "I need 80" constitutes an opportunity to offend. And Justice, to return to your point on what could have the police done differently during the call, it is open for police to ask merely investigatory statements police may make without triggering an opportunity to offend. Phrases like "I need product," "Can you hook me up?" or "Are you around?" These don't constitute opportunities to offend. The Ontario Court of Appeal in Ralph supports this proposition. In conclusion, this case is about striking a balance between the right to privacy and police ability to investigate crime. It is about keeping state power in check by holding police to an evidentiary standard that must be satisfied before action is taken. The respondent is not asking this court to add more responsibility to the police or make the police's job. Chief Justice, may I have 10 seconds to finish? The respondent is not asking the court to make the police's job any more onerous. It is only asking this court to enforce a minimum standard that ensures human dignity. The respondent asks this court to dismiss the appeal and affirm the finding of entrapment in favor of the respondent. Those are the respondent's submissions.
Thank you. Safe to say we'll reserve our decision here. So I'll say well done, it's over in that respect. What you're gonna get now is some feedback from everybody up here. Don't take anything too personally. A lot of times it can seem more constructive about giving tips and so on. It's not meant to be negative, but it always sounds that way. Famous last words. But I don't know if we wanna start, who wants to start? We'll go one way or the other for feedback, or do it matter? Okay.
So yeah, congratulations. We know you've put tremendous work into this. Just preparing the research and preparing a factum is very, very time consuming. You've thought of 101 things and only maybe about 6 come up in a moot. But that's the way it is in a real appellate court as well. Your time is very tight and you barely get off. Most often in my experience in appellate courts, you don't get very far into your factum, in your presentation. The judges stop you, they interrupt you, they ask questions, so forth. A few things that I noted. One is your time management. This is something that all of us commented on in our discussion outside the room, that you do need to be able to manage your time. And you got shortchanged in your time. But appellate courts do, give you time limits, 60 minutes, 45 minutes, and you've got to be able to be prepared to deal with complex legal issues, factual issues, and the nub of your argument in that time. And they interrupt you and you go off course from what you had prepared. A few other suggestions or comments. Your etiquette was good. It's very, very important, as you all did, to keep your composure, because judges do interrupt you, just as I did. And I did it right off the top for you, just to test you. But I did have that question. It was a question in my mind around the overall discussion and stats of how many people have died around drug overdoses. And what's the best approach to deal with that? But the real issue here was a different one, and that's simply, should there be a stay of proceedings or not, and should the court, in order to do that, find entrapment or not? It's very important to keep your composure, as you all did, because that's crucial no matter what. You have to be able to keep your composure, good etiquette, good manner, make eye contact with the judges, answer their questions, and fight back if you have to, right? I mean, just because you're interrupted by a question doesn't mean the judge is right. Judge could be wrong. It's your job to persuade the judge, but you do it politely, right? And firmly, and you explain why. You get to the point. That's a key. Get to the point. The other thing is pick up clues from what the judges are asking. It's clear, if the judge keeps harping on certain points or even once asks you about something, it means that's material to the judge, to the outcome of the case, not what you've prepared, because ultimately you want to succeed in your argument. You want to achieve the result, either if you're seeking a conviction or if you're seeking an acquittal. And so what is this trier of fact asking me, and how can I bring him or her to my side? So get right to the point. I understand the legalistic aspect of this, your law students, your learning, and that's part of your research, but very, very crucial to all court cases at trial level when you make your submissions and at appeal is what is the evidence? Law is great, but what is the evidence? What are the facts? And ultimately, good, I think, judiciary is going to look at what's the right thing to do. What's the common sense thing to do? Yes, we have to frame it in a legal framework. Yes, we have to be mindful, or judges do, of precedent, but we're not slaves to precedent. It can be changed. That's why I said, why should we continue to follow MAC or whatever? What about the fact that no other jurisdiction, applies this type of reasoning? What's the right thing to do? It's a very difficult case you had because it's hard to reconcile the two decisions, right? Ahmed and Williams, because the facts, you're really splitting hairs. A different panel of judges might have gone differently on the other way. I think consistency was really, really important. What ultimately is the right thing to do? What are the charter values here? What's the purpose of the law? Probably, in my experience, I would have upheld the conviction. I wouldn't have found that this is the kind of entrapment that the law of entrapment was designed to apply. But, who am I? The Supreme Court of Canada has said otherwise. But that's what I struggle with on the facts here. All right, there's a purpose to the criminal law. And what if if it's the facts establish it, proof beyond a reasonable doubt, he'd pled guilty, right? So that wasn't an issue. Then what would the ordinary reasonable person on the street think? Not just ordinary person, but the ordinary reasonable fair-minded person. And I couldn't find in my own reasoning that the police misconduct or lack of a perfect or better investigation ought to have excluded the evidence or warrant the remedy. But that's just my own view. That's just my view, and I don't think the outcome of the legal outcome is important. That's not what we're judging here or determining. It's your advocacy. You will be put in positions of arguing all kinds of cases in your career. Some of them are going to be very difficult. Some of them you may even personally, and you will disagree with, but your job as an advocate is to take the law and fight fiercely for your client. One more thing, because I've gone at a bit length. If you think you're down the wrong track and a judge stops you and the judge asks a question and you think the judge might be right, just concede the point and move on. There's an old saying, give an inch, gain a foot. I tell my clients also in trial when they prepare to testify, I say to them, nobody's saying you're perfect. If you did something, this little thing wrong or you don't know, just say so, but you'll enhance your credibility with the trier of fact. And similarly with counsel, right? There's nothing wrong. I've seen counsel sometimes really dig in, and they lose themselves on really might not be the most important point in the case to dig in on. So you didn't demonstrate that necessarily. I was trying to push all of you about, well, what's the big deal about reasonable suspicion on the facts of this case? I don't see it. So tell me why I should go your way. And in the end, you need to do a summary. We've taken up your time. We've interrupted you. If it's gone very quickly, your time is pressed. But in the end, you'd have to make a closing submission to say, judges, honorable judges, do this because, boom, even if it's in 30 seconds or a minute, remind us what you want to achieve and why. And what happens in the discussion, the questions in the presentation might help you figure, okay, this is what I've got to say, because this is what's probably going to achieve the result for me. And so I don't recall really too much of a submission, a closing submission from you to saying, judges, you should do this because of this. It was in your factum, yes, but your oral presentation is the time to work out your factum and really persuade us, right? So I hope that's useful to you. But, congratulations. You did very well. Your presentations were professional in many respects, compared to even experienced lawyers. It was the way it is in an appellate court. It goes very quickly. It goes off track because they start asking you questions. The next thing you know, it's over. But you got to always hone in on what do I want here? And at the end, got to say to the judges, this is what you should do and why. Even if your time is very, very tight. Always do that. Remind them. Bring them back to the essential core of the issue, right? Don't get bogged down into too much minutia of detail. What's the big picture here? What does justice require? I kept asking you that, right? But I know you have to defend a position, so it was a tough position to put you in. But thank you very much. You did a great job. Congratulations.
So I'll just pick up on some comments as well. Some general nature is that your factum is your backbone. Your presentation is adding to it. You're adding limbs or appendages or whatever we want to call it. Your backbone's still that factum. And I think both sides did a good job at the intro level, every speaker did, of telling us where you started on your factum. But there wasn't a lot of follow-up as you went further along. Like, so you could pick up again maybe 5 or 6 minutes later as you've gone through and say, okay, I'm now on paragraph 42. Like, if you want me to follow along, you can give me some cues once in a while just to try to throw that in as to where you're at. Because you don't want to see me up here fumbling with the book and not sure where you're at. The other thing to watch for is if you get caught reading your notes or you're reading a part of your factum, which is fine. I don't have a problem with that if it's a critical point. Tell us what what paragraph number you're on the factum. That immensely helps because I can read it probably faster than you're going to say it, but at least you got me to read it at the same time you're saying it. So remember that we receive information both visually as you're doing your presentation as well as orally. So you're getting as much of that information of your argument is getting conveyed to the justices. The other thing I think that's important is to pick up on Bill's idea here is that you need to tell the justices what order you want when you start. And when you finish, tell the justices what order you want. You always start and you always finish. I do that in chambers. I would do that in appeal court. You don't want any confusion over knowing what position and what orders that you want to be made. Always be clear at the start and at the finish so the judge always knows, or the justices in this case, always knows what it is you want. I think everybody did a pretty good job of eye contact. I've only have some minor notes of times where there might have been too much reading, but not massive. That wasn't terrible or extraordinary. Time management is a difficult thing, and it could have been unfair to have the clock over to the far side. Like if it was up here, you might have saw it and it was in your vision. So I don't know, that might have made a difference. So I'll give you the benefit of the doubt on that. But you do want to take those breaks when you're asked questions, maybe from a judge, to take a quick peek at the clock or something where you have a chance. You can still listen and just manage your time effectively, because that's a challenge. It's always a challenge to manage your time. Overall, I thought everyone tried to answer the questions they were given as well as they could. It's very important you understand the question that's being asked of you, and it's okay to concede. I was trying to get you to concede a point where I tried to change the facts a little bit, and you waffled a bit, but you did concede that it was possible, and that's fine. It really didn't matter. It doesn't affect the outcome of your argument because it was a different set of facts again. So I think you saw that, and that was a good point. You can get caught up in that groupthink mentality where you have to keep fighting to get your answer, but if you're getting nowhere with it, it's time to move on because you have several arguments to make. And I can say this from practice. I tell clients all the time that you could take a different lawyer and they're going to see that these are the top 5 arguments to win your case. And I might see a different 5, and I might rank them ordinally in a different way. I might have 1, 2, and 3, and Bill's, my 1, 2, and 3 are 3, 4, and 5. Everyone has their own view of how they see those arguments and how you present it. So even if you're losing traction on a particular argument, sometimes you can concede and move on to the next argument. Obviously, if it's critical to your case, you're going to want to keep defending, but don't defend just on the principle of being oppositional, because you're wasting that valuable time where you can say more things and get your point home to the court. So overall, good. I thought the tone was good. Everyone was loud. Your posture was good. So all of that stuff, those are good, presentations. The only other minor point I would say is that, and you'll learn this more from experience, but both of you are teams. So when your partner goes over time, I might try to pass a note or, cough or have a signal or whatever it might be, because you're working together. And I think even in a court setting, if somebody is stuck or maybe doesn't understand the question and your partner does, there's always an opportunity to try to do that in a respectful way and get the answer out that you're trying to get to support your factum again. So those are the general comments. Overall, I think well done. So.
Well, let me just build on a couple of those. One of the challenges when you're doing an oral presentation is you can see questions as disruption. Right? It kind of throws you off. You know, I'm on this paragraph in my mind. I want to get to that next paragraph, and then this question comes out of the blue. But you have to remember, your goal here is to persuade the judges. So the question is the opportunity for you to figure out what it is they're concerned about. And you want to welcome those questions, even though it may throw you off and you're now having to jump 6 paragraphs ahead in order to answer that question, but it is that opportunity to persuade. So don't feel kind of, you know, almost aggravating. They're interrupting my argument. Now, you didn't disclose that, but you do want to really see it as an opportunity to persuade. And, you know, and Justice Sundu here kind of came back on this several times on his particular concerns, and they weren't quite getting answered. And so when you come up as the respondents, this is your golden opportunity to learn from the questions that were given to the appellants. And because that's suggesting some concerns that the bench has, and you want to be thinking, well, okay, how do I answer that to get them on to agree with my argument? So you get an advance opportunity to know what those questions are. So you really want to zero in and seize that opportunity when it's there. Really got to keep people connected to your paragraphs of your argument. Because it was somewhat challenging. If you read the paragraphs, it gets that much easier to find them, but your goal is not to be reading it, but it is to have us following it. So when you moving on, and if you skip a couple of paragraphs, maybe perhaps because of your answer to a question, again, bring us back. I was on paragraph 36, but now I'm on paragraph 40 in light of that question, so that we're with you and we're reading it again. We've read it ahead of time, but now we're reading it again. We're reading it in light of what you have to say in that regard. Focus on your strongest points in your argument, and particularly when time is limited, you start getting married to every paragraph you've got. Well, rank them in your own mind. What are your strongest pieces? And that's what you want to hit. And particularly when you've only got a couple of minutes left, you want to go right to the best that you've got, because you don't want to leave your strongest arguments unsaid because of a time issue. Drive home the contrast between your case and prior cases. So you're appealing, why is your case different from some of the other cases? Particular challenge that you kind of have in this regard is because of the 2 cases going forward. And with different outcomes, you've got to focus on why yours is different, why it should be treated in a particular way. You all were clear and articulate, good tone, that's good. Very good eye contact, it was good. Make sure that you link the facts to your argument. And this, we were all looking at that. Justice Sundu particularly raised it a lot, but so you've got to be able to respond to those factual questions and link it in so that you know that, well, that's why. So the second conversation, how is that really different from the first? How is this case on that point different from Ahmad, et cetera? So you've got to know that. Finally, the end, always have a summary, right? Just before, however much time you got left, make sure you've got a nice tight summary. My 3 main points are, or 4, or 2, or what, I think the fundamental reason why you should give this order is because. So that's how you're closing it, because that's what you want the court to be focused upon as they're getting up to leave, is debating that issue in their minds, okay? But an excellent job. It was not easy, particularly with the clock there, and feeling a bit under the time pressure. Going first is an issue, and then when you're respondents, you actually have the easier opportunity, both because you're not trying to persuade to a reverse, but also because you've heard all of that to the appellant. So take full advantage of it. But well done. Thank you for doing so.
Alrighty, thank you everyone for your patience. And without further ado, we will announce the top 3 teams. I will note that we do have just 2 of the teams here. One of the other teams is not here. So we will start with the team that has finished 3rd place overall. And the 3rd place finishers is our appellants today, Azat and Saba. The 2nd place finishing team, who are not present here this evening, is Kyle Komorensky and Ashwin Gupta. So we send our congratulations to them. And without further ado, the first champions of the inaugural Thompson Rivers University internal moot competition is our respondents today, Allison and Sam McDonald.
Oh, in fitting with the Olympics, a medal.
And so this trophy will be showcased in the front room on the 4th floor, and winners will have their name put on that every year. And we hope that this will be a tradition that TRU will continue into the future. We're really excited that we were able to do this to celebrate 10 years of law graduates at Thompson Rivers University here in Kamloops. And so this will conclude the first annual TRU internal moot competition. I'd like to thank everybody who came out, but especially the Oral Advocacy Club would really like to thank our judges that were here this evening. And so we have some gifts for you. I will allow Serena, who is the executive of the Oral Advocacy Club, to present you with these gifts and a token of our appreciation. Thank you so much, Justices. And we'd also like to send a really big heartfelt thanks to all of our volunteers who volunteered their time, Madam Registrars who are volunteering their time, and we also have a small team of volunteers who this would not be possible without. So thank you. And that's everything. So everyone have yourselves a great night, safe travels, and we hope to see you soon.